All right. Thank you. Good morning, and again, good morning not only to those in the hearing room in the inquiry offices in Edinburgh, but also to our wider audience following us on the YouTube feed. Now, I'm about to ask Mr. McKenzie to resume. Mr. Barn, I think your agents have been contacted by the inquiry in relation to your speaking note, which we would very much value having, together with Dr. Inverarity's comments, but I understand that that's in hand. Thank you. Mr. McKenzie.
Good morning, my Lord. Thank you. My Lord, just on the written aspect of matters, I will be providing your Lordship with my speaking notes as well. That will follow on after today. And that means I can take the matters I wish to take today fairly quickly. In particular, I won't labour any references. Those will be contained in the written material. And I hope that that will meet with your Lordship's approval. So it's 2 points of detail, my Lord, coming out of this the closing written statement of the Health Board. The first one is from paragraph 17 of that statement, where assertions are made about the performance of Multiplex on the project from the Health Board's perspective. It suggested that Multiplex, from their perspective, performed extremely poorly, and they referenced the extent of delay in completion, which is, I think, different from the delays to the opening that were caused by the critical care ventilation. And they also referenced the fact that the technical schedule to Settlement Agreement 1 comprised 80 items, and it is said that that gives some justification of or indication of just how unsatisfactory IHSL's and Multiplex's performance had been. So the point I wish to make is simply there's no evidential basis for any conclusions to be reached about responsibility for project delays generally. That's as opposed to the delay to opening caused by the critical care ventilation issue, or in relation to any other aspects of Multiplex's performance on the project. That wasn't the focus of the inquiry. And the inquiry is therefore simply invited to note that these broad assertions that are made by the Health Board are disputed by Multiplex. That's the first point, my Lord. The second one is under reference to paragraph 20.1 of the Health Board's closing submission. And there is a suggestion that the Health Board had no choice but to move away from the original project requirements, including the requirement for a full set of room data sheets at financial close. It's said on behalf of the Health Board that that is unfair and overlooks the fact that the Health Board in reality did not have a choice. And I just wanted to remind your Lordship that the evidence was to the effect that the board had already taken a decision at tender stage not to produce full room data sheets, with the environmental matrix being used as the alternative briefing tool. And that decision was taken on the basis of cost And that comes from the oral evidence of David Stilley. As I say, my lord, the exact reference will be given up in writing. The evidence also showed that IHSL produced room data sheets for all room types, including critical care, for financial close. And these showed that 4 air changes per hour were the parameters being used. And this was not commented upon by either Mott MacDonald or the Health Board.
Just, I may be misremembering this detail. We're talking about before financial close. Yeah. Now, my memory, and just tell me if I'm wrong about this, is that some room data sheets were produced, but not a comprehensive set. So I'm right about that.
Correct.
Right. But the point you want to make is that among the room data sheets that were produced were room data sheets in respect of all spaces in critical care.
I think we'd have to double check whether it was all rooms in critical care, but certainly there were for some of the rooms in critical care.
And I mean, given your what you've already said, am I to assume from what you say that that would include the single bedrooms and the isolation bedrooms?
Single bedrooms and multi-bedrooms.
Right.
My lord, I think we'd have to double check if there were any isolation rooms included in that.
Right. And IHSL had produced that information and provided it.
Yes, it was provided prior to financial close, and there was no adverse reaction from Mott MacDonald or the Health Board. Thank you, my lord. That's all I wished to say. So unless I can be of any further assistance, those...
No, thank you very much, Mr. McKenzie.
Thank you.
Mr. Ross? No, that's stuck, Mr. Ross. Yeah. Again, my apologies, Mr. Ross, for not reading my list accurately yesterday.
Not at all, my lord. Though I didn't realise it was going to be such a long time before I would be back in this position.
Right. Can I ask you to keep close to the microphone? As I've said on a number of occasions, my hearing is not that great.
Certainly, my lord. For the most part, NSS rests on its written closing statement and on the paper entitled NHS Scotland Assures Position on Approach to Research, including Ventilation. That was submitted last week to the inquiry and is the first document in bundle 13. I noticed in going back over the closing statement that there is a typographical error that I should perhaps draw your lordship's attention to. I don't think it's necessary to turn up the page, but I can give your lordship the reference. In the first sentence of paragraph 12, at page 361 of the closing submissions bundle, the reference in the opening sentence should be to paragraphs 434, not 334, 434 and 435 of the closing statement by counsel to the inquiry.
424.
Yes. Subject to that correction, NSS adheres to and rests upon its closing statement. And there are only a few other matters on which I offer very brief observations. And these are certain matters raised in your Lordship's note, which was sent to core participants last week. With regard to paragraphs 1 to 5, NSS has no comment to make, and it's not invited to comment on paragraphs 6 or 7. So I can begin by looking at paragraph 8. Which invites core participants to comment on whether they consider, in relation to the matters canvassed in evidence, there to be any weaknesses or drafting deficiencies in the interim 2022 version of SHTM 0301, which would merit further revision. As is mentioned in NSS's research paper at paragraph 20, this guidance is under continual review and will likely continue to evolve over time. NSS will consider carefully any views expressed by other core participants at this hearing. And of course, any observations or recommendations which your Lordship may make in due course. And in that regard, NSS looks forward to receiving the detailed comments from Dr. Inverarity, to which Mr. Barn referred yesterday in the course of his submissions on behalf of NHS Lothian. And NSS, on receipt of that paper with comments, will give it careful thought. We haven't seen it yet, but it will be considered carefully. With regard to paragraph 9, which relates to potential recommendations for an interim report, NSS has made some comments on those recommendations in its written closing statement and does not wish to add anything to these. As to paragraph 10 of your Lordship's note, that relates to NHS Scotland Assure. NSS agrees with the proposition from counsel to the inquiry that the arrangements put in place by NHS Assure represent a robust challenge to help improve board's governance and compliance with guidance. Having said that, Assure is at a relatively early stage of its journey. As it has emphasised in other material submitted to the inquiry, it is committed to working collaboratively, and it welcomes feedback from health boards and others. It will therefore consider carefully observations by other core participants, including those made yesterday by Mr. Barn on behalf of NHS Lothian, as well as, naturally, reviewing carefully in due course your Lordship's report or reports. Finally, my Lord, paragraph 12 requests a separate written report from NSS by the 28th of June, and I can confirm that that will be provided. And unless there are any other matters on which I can assist your Lordship, these are the submissions for NSS.
Perhaps two matters. Can I take you to question 2, which declined to answer? The reason I'm directing it to you, Mr. Ross, is that I see you as representing the, as it were, the custodians of the guidance documentation, and therefore perhaps having insights that others might not have. I'm asking the question as a matter of generality. There's a suggestion in that question that if in the course of a healthcare construction project there is a change in design. Now, I'm leaving aside the question as to whether there was or was not in this case. From your perspective, would that reset the H-scribe process in respect of the relevant works to stage 2? Now, Mr. Barn addressed that point yesterday, and I'm going to get his view in detail. But does NSS have a view on that?
I think, my Lord, that it is quite difficult for NSS to answer that question in the abstract. Mm-hmm. I think it would be, it is, I'm not sure whether this is an exact parallel, but it may be something in the nature of a mixed question of fact and law, rather than one to which a simple yes-no answer can be given. What I can do, my Lord, is that I can, during the break today or at lunchtime, see whether I can have a discussion with NSS to see whether they are in a position to say more.
Well, I would value that. And similarly, in question 3, to an extent this may be academic, having regard to my understanding of the answers, again, of Mr. Barn in relation to this project. It's in relation to validation as required in terms of Chapter 8 of SHTM 0301. Now, proposition that is put forward for comment is, and as I understand Mr. Barn, he accepted the proposition that in a situation such as under this contract, notwithstanding that HScribe has been gone through, notwithstanding that there is provision for our, using it as a term of art, independent tester, nevertheless, who has indicated his satisfaction, nevertheless, a Chapter 8 of SHTM 0301 requires the Healthcare Authority to carry out a validation of, for example, ventilation systems, although the text of Chapter 8, I think, tends to concentrate on theatres. Does NSS have a position on that?
If Laura will just bear with me for a moment. My Lord, I think the position here is that the requirement to instruct independent validation is not something which is express in terms of the guidance, but I think NSS's view would be that it would be in keeping with the ethos and spirit of the guidance that an independent validation of the ventilation systems would be required.
I think I'm particularly thinking of the note which either begins chapter, I think it's the note which begins Chapter 8. But you would see that it was at least in consistent with the spirit of the guidance.
That is as I understand it. I think that yes, the terms of the note, I think, are that that validation of these systems should therefore be carried out by a suitably qualified, independent, authorised person appointed by the NHS board.
That's what I had in mind.
So I think the answer to that is yes.
Right. Thank you, Mr. Ross. These were the only 2 points I wish to raise.
Thank you, my Lord. And if I have further comments from NSS in relation to the issue your Lordship has raised about paragraph 2, I'll perhaps provide a short note.
Thank you.
Thank you.
Now, the next co-participant I would invite to address the inquiry is the Scottish ministers who are represented by Ms. Crawford.
Thank you, my Lord, and good morning. My Lord, first of all, the Scottish ministers are grateful to my Lord, the chair of this inquiry, for the opportunity to make oral submissions on their behalf. As will become apparent shortly, the oral submissions which I make on behalf of the ministers are at a relatively high level, the reasons being which I will develop shortly under reference to the statutory framework for the provision of healthcare in Scotland. And my Lord may also have noted from the closing statement for the ministers, which I formally adopt for this morning's session, was also at a high level, again for similar reasons having regard to the statutory framework. That being so, my Lord, I will address, and again very lightly, points 1, 8, 9 and 10 in the paper provided by my Lord, because the other questions address matters of detail which the ministers under the statutory framework for the delivery of healthcare are not involved with, in the sense of an operational involvement. If the inquiry comes to the view that there are concerns about the existing framework under which healthcare in Scotland is delivered, for example, that the ministers should have greater involvement in operational matters and delivery, that may exceed the terms of reference, but in any event, and perhaps more pertinently, I would submit, would require far more detailed consideration than this inquiry has had the benefit of. Then there would require to be extensive consultation across all sectors, public and private, throughout Scotland, consultation with public bodies, industry, businesses, patients, charitable sector, and indeed perhaps other jurisdictions. Because if this inquiry was to come to the view that the existing framework did not operate satisfactorily, it would be clear that some form of structural change would be required, which, as I've submitted, would require extensive consideration, consultation, and thereafter parliamentary debate.
I understand that, Ms. Crawford, but did I gather from what you've just said that it might be open in a world of possibilities for this inquiry, with its terms of reference, to finding maybe too strong, but let's use the word finding anyway, that the framework did not operate satisfactorily, leaving aside what might follow from that?
I think my Lord could make that suggestion or comment to that effect, but that of itself is probably as far as my Lord could properly go, because my Lord has not been provided with, as I understand matters, any material to suggest how, if it didn't operate properly, it could have been done better. If in anything else, my Lord has perhaps learned from this inquiry that delivery of healthcare is a very complex process indeed. And just pausing there for my Lord, thinking a bit more about my Lord's question to me, it may not be entirely satisfactory if my Lord were to make such a comment without indicating a basis, a proper basis for that, or indeed which particular aspects of the existing framework did not operate satisfactorily. So a general observation, thinking matters through further, may not be entirely helpful to the ministers once they've seen my Lord's report. My Lord, a general submission before I proceed to address my Lord on that statutory framework. The ministers, of course, wish to acknowledge the undoubted distress, anxiety, and upset that will have been experienced by patients, families, and staff caused by the delay in opening. Not to say their experience of the less serious but still important inconvenience. So nothing which I submit on behalf of the Minister should be regarded in any way as seeking to move away from recognition of that very real distress and anxiety. As will have been clear from the former Cabinet Secretary's evidence, however, the decision to delay opening was taken by her, for which, of course, the ministers are collectively responsible and accountable. The decision was taken by Ms. Freeman to ensure the paramountcy of patient safety and that their care and safety would not be compromised. It is submitted that, having regard to that paramount consideration, weighed against the undoubted distress, anxiety and upset, the balance firmly weighed in favour of a delay to opening. My Lord, I mentioned a moment or two ago the statutory framework, and my Lord may have been provided with a copy of Part 1 of the National Health Service Scotland Act of 1978.
I'm pretty certain I have been.
I can take this relatively quickly, my Lord, because I don't intend this to be a legal debate. It's simply to direct my Lord to certain relevant provisions. And by way of general introduction, my purpose in doing so is not in any way, of course, to deflect responsibility, the responsibility of the Scottish ministers for the health service in Scotland, but simply to explain how that health service, the provision of that health service is effected, is secured. And my Lord may recollect Ms. Freeman in her evidence being clear that she was wholly accountable to both the Scottish Parliament and to the people of Scotland in that regard. Albeit the actual delivery of healthcare services is provided by individual health boards across Scotland. The National Health Service Scotland Act, which has been subject to numerous amendments over the years, initially enacted in 1978, Part 1 is headed up organisation. And in Section 1, the ministers have a duty, headed up as a general duty, to promote in Scotland a comprehensive and integrated health service designed to secure A, the improvement in the physical and mental health of the people of Scotland, and B, the prevention, diagnosis and treatment of illness. And for that purpose, to provide or secure the effective provision of services in accordance with the provisions of the Act.
As you say, the Act has been much amended, and a lot of the amendments quite recent. There's a bit of archaeology in the sense that the Secretary of State continues to be mentioned, but am I right in thinking that where I see the Secretary of State, I should read Scottish ministers?
Yes, indeed, and that comes from the Scotland Act itself.
Yeah.
My Lord, reading further into the Act, will see that some provisions mention the Scottish ministers and some mention the Secretary of State.
Yeah.
And my Lord perhaps immediately alighted upon Section 1A, with the duty of the ministers to promote the improvement of the physical and mental health of the people of Scotland. Then if my Lord turns to Section 2, my Lord will see reference to health boards who are to be constituted, reading short, for the purpose of exercising functions relating to the health service and for making arrangements for the provision of services. Reading further into the document or the extract from the 1978 Act. If I could invite my Lord to turn to section 2A, which in my print is at page 5. And my Lord will see subsection 1. It is the duty of every health board, reading short, and of HIS and the agency. Just pausing there, my Lord, HIS is, of course, Health Improvement Scotland, and the agency is the Common Services Agency, which now operates under the label of NHS Scotland, National Services Scotland.
I mean, the NSS is a sort of trading name.
Well, putting it crudely, yes, and probably not legally accurately, but yes.
I apologise if that offends anyone. But I don't think,
Indeed.
I think that's its status.
Anyhow, it is the duty of those bodies to promote the improvement of the physical and mental health of the people of Scotland. And they're given powers, a number of powers in subsection 2. Then reading on to section 2C, the functions of every health board are listed. Subsection 1, every health board, A, must, to the extent that they consider necessary to meet all reasonable requirements, provide or secure the provision of primary medical services as respects their area, and B, may, to such extent, provide or secure the provision of primary medical services as respects the area of another health board. And then the services may be performed outside their area. Health boards are given a wide power in subsection 2 to make arrangements to provide primary medical services.
Primary medical services, does that include hospital services?
As I understand it, yes.
Right.
Then if I might invite my Lord to read on to internal page 14, section 10. Which contains provisions relative to the Common Services Agency. And the agency at 1A has the functions conferred on it by this Act. And my Lord needn't trouble himself with section 62 of the 2014 Act. Schedule 5 relates to the composition of the agency. And subsection 3, the Secretary of State, the Ministers, may by order delegate to the agency such of their functions as they consider appropriate. Then if I could invite my Lord to read on to section, and it's apparent this Act has been copiously amended to section 10ZA, although that's at page 16, only a couple of pages further on. Sorry, my Lord, it was the next. Wasn't that section, forgive me. If I could invite my Lord next to look at section 10A, which addresses Healthcare Improvement Scotland. And its functions are set out at section 10C. Amongst other things, at subsection 1A, functions in relation to supporting, ensuring and monitoring the quality of healthcare. Supporting, ensuring and monitoring the discharge of the duty under section 2B by each body to whom that section applies, in other words, health boards, and so on. The evaluation, provision of advice to the health service. A long list of functions which I don't think it serves the purpose of this morning to read out at length. Then if I might next invite my lord, and this is where I got my numbering wrong, invite my lord to look at section 10Z1A, IA, sorry. Which is to be found on page 41 of the print. Subsection 1, for the purposes of its functions as they relate to the provision of independent health, sorry, my lord, I won't invite my lord to look at section Z1A. I see it's addressing independent healthcare services, which is slightly different.
Right, okay, so
My lord should probably just put the red pen through my reference to section 10 Z1A.
right, yes, I mean, what I'm looking at the moment is, as you say, a much amended section.
Indeed.
10Z14. I mean,
114, I think it might be, yes.
I don't know if I've come across a section that has run out of letters and had to,
Indeed.
had to start numbering.
Indeed.
But in any event, that is not a provision.
No, I'm not. I don't think it's
you're
particular
drawing
assistance.
my attention.
No. Not for the purposes of making the broad submissions about the framework. If I could, again, looking to letters and numbers, invite my lord to next turn up a section of provisions relative to, first of all, quality, section 12H on page 51. Subsection 1. It shall be the duty of each health board, reading short, and of the agency to put and keep in place arrangements for the purpose of monitoring and improving the quality of healthcare. So a general duty there on the part of the health board and indeed the agency relative to quality and monitoring and improving the quality of healthcare. They're then, over the next page, commencing at section 12(1)A, proceed to list a number of duties relative to staffing.
I mean, this is not criticism. You say 12(1)A, is it 12IA?
IA, sorry, it's my eyesight, my lord. IA. And the primary responsibility, taking these various provisions short, is that the primary responsibility is on the part of the individual health board. Albeit that the ministers have a duty in section 12IG at page 57. Subsection 1, the ministers must take all reasonable steps to ensure that there's a sufficient number of nurses, midwives, medical practitioners, and other such types of employees as may be prescribed, available to every health board. So there's a general duty there, but the primary duty to ensure that healthcare facilities are appropriately staffed rests with the relevant health board. And my Lord, reading on in the bundle, in the extract, we'll see that there are a number of specific provisions relative to staffing. And finally, in this excursive, or perhaps penultimately in this excursus, if I could invite my Lord to turn to page 68 of the copy and section 12J. Subsection 1 provides, in exercising their functions in relation to the planning and provision of services, which it is their function to provide or secure the provision of, under or by virtue of this Act, health boards shall cooperate with one another and with special health boards and the agency with a view to securing and advancing the health of the people of Scotland. So a general duty for health boards to cooperate amongst each other, between themselves. And we see a similar duty, finally, in section 13 over the page. In exercising their respective functions, health boards, HIS as respects its health service functions only, NHS Trust, local authorities, integration joint boards and education authorities shall cooperate with one another in order to secure and advance the health of the people of Scotland. Now, with apologies, my Lord, for taking my Lord through fairly torturous statutory provisions, but the submission I make, and the purpose of doing so, was to explain to, or seek to explain to my Lord, that the ministers have this high-level overall responsibility to secure the provision, but the day-to-day management, delivery, operation of that is carried out by the relevant health boards in conjunction with the help and assistance they derive from the agency and from HIS, and indeed from other knowledge acquired through its cooperation with other health boards and other authorities.
Don't apologise, Miss Crawford. I have had occasion to try and follow the current structure of the 78 Act, and I'm grateful for any assistance.
Well, my Lord has my sympathies if he's already had to crawl through the Act. My Lord, how this operates in practice was explained by Miss Freeman in her statement. And I shan't invite my Lord to turn up the relevant paragraphs, but those paragraphs can be found at paragraphs 9, 13, 14, 17, 19, 20, 22, 23, and 26. I just make the following observations under reference, first of all, to paragraph 17, or draw to my Lord's attention paragraph 17, which explains that the Director General, as that person is described for health and social care, is also the Chief Executive of the National Health Service in Scotland. Paragraph 19 sets out that there are regular meetings between the Director General and the Chief Executives of health boards in Scotland. And paragraphs 20 and 22 explain that there are regular meetings between the Cabinet Secretary the Director General, and Health Board chairs.
Regular meetings between the Director General and the Chief Executives of the Health Board.
The chairs.
The chairs.
Further information about how this works in practice is also provided in Malcolm Wright's statement, the former Director General, of course. In paragraph 15, he tells us about the body known as the Health and Social Care Management Board. And he again sets out in paragraph 20, I think it is, the meetings which take place with himself, with health boards, and with the board. In paragraph 16, he explains that health boards are accountable for delivery of healthcare. And at paragraph 20, he explains the process in relation to healthcare projects, in particular infrastructure projects. 25. Sorry, what did I say? Oh, 25. Between paragraphs 79 and 85, Mr. Wright explains that NHSL were escalated, as it's described, to level 3. And at paragraphs 101 to 103, he describes escalation to level 4. This escalation framework is part of the ministers ensuring that health boards do, in fact, deliver healthcare. And that is under reference to the escalation framework, which is monitored by annual reviews.
Sorry, monitored by?
Annual reviews.
Thank you.
My Lord will find the escalation framework in volume 13, bundle 3.
Is that the right way around?
Is it bundle 13, volume 3? I think it's volume 13, bundle 3.
It is bundle 3, right? You're right, and I'm wrong.
It's bundle 13.
Just like the 1978 Act, the numbering can be confusing.
So, Drew, it's
bundle 13, volume 3.
Right, okay. I'm told, and I rely on this, it's bundle 13, volume 3.
Okay.
Anyway.
Whatever.
I think we know where to look. Page number?
Annex 1 is at page 685. And that Annex 1 is an annex to a paper presented to the Management Board, the Health and Social Care Management Board, of 10th July 2019, which can be found starting at page 683. Annex 2 to that meeting paper contains the annual review of NHSL for 2017-2018. And pages 687 to 688 set out the actual framework itself. And as my Lord may recollect, there are 5 levels. Level 3 is a level to which the Health and Social Care Management Board have responsibility for. A decision to escalate to level 4, as Mr. Wright explained in his evidence, is one taken by the Director General. And level 5, being the top level, is a decision taken by the Cabinet Secretary, not least because level 5 involves ministerial intervention, direct ministerial intervention in the delivery and provision of healthcare by a particular health board. And it is only in that event, if matters have got to a stage, and it's set out in the criteria for reaching level 5, that the ministers directly intervene.
Just in the context of discussion on its structure, my guess is that the framework is an administrative tool. It's not mandated by any statutory provision.
Except buried in the 1978 Act, you will find a requirement for ministers to produce guidance and directions and the like. I don't have that provision immediately to hand.
Anyway, so that would be the Scottish Government's action, as you've just described, would be based on whatever the provision is, which imposes an obligation on Scottish ministers.
I think that is an obligation, but I will double check. I don't have the provision relatively to hand. If my Lord will allow me, I would perhaps provide it by way of a short note once I've double checked the provision.
I mean, I appreciate this is fine detail, Ms. Crawford, which is probably not, in the end of the day, terribly important. But in the context of a discussion of getting the structure right, I would value that.
I will do so, my Lord, but rather than me flicking through the Act this morning, I would rather spend a bit of time to identify the correct provision.
I can understand.
Thank you, my Lord. Now, my Lord, obviously I've taken my Lord to at least some of the provisions of the 78 Act and the escalation framework, again to illustrate how the delivery and operation of healthcare in Scotland works, both as a matter of law and in practice. And the submission is, the broad submission is that that is an appropriate and an effective way to secure provision of healthcare, as opposed to an overly centralised system run and managed directly and operationally by the ministers. And picking up a submission I made earlier, if the inquiry were to come to the view that there was something not quite right about that, and that there should be more direct operational control of some sort and in some way, that, harking back to my original submission, would raise a number of complex issues of, I venture to suggest, a highly sensitive political nature, which ought properly to be addressed by the Scottish Parliament following a detailed consultation exercise. Now, my Lord, with that overview, I would, on behalf of the ministers, make a number of points without forming a view one way or the other, more by way of observation and comment. It does appear to the Scottish ministers that the design brief lacked clarity. In that regard, it is not for the ministers to resolve, either then or now, any ambiguities that may or may not have existed, whether at the time of the procurement itself or as the project developed through all its stages, or as the project developed through all its stages, or indeed to suggest a concluded view submission before this inquiry. The obvious point being, of course, that the ministers were not one of the contracting parties, and having regard to the framework under which healthcare is delivered, it was not for the ministers to negotiate contractual terms nor was it for the ministers to determine what were the requirements, construction requirements as they're described, of NHSL, or indeed any other health board.
I am right in thinking that the project agreement is in, I mean, it may be a development, but is based on a text produced by Scottish Futures Trust.
Correct. And I was going to make some observations about the NPD contract as it's described. In that regard, the ministers would align themselves with the comments of the Scottish Futures Trust in its closing statement to the inquiry. In broad terms, to the effect that questions of risk transfer and the like are irrelevant.
Sorry, are irrelevant.
Are irrelevant are irrelevant because if the requirements in the design brief were clear, there would be no need for changes with perhaps a consequent effect on the risk. There would be no need for changes as the project progressed, and any changes which went out with the design brief brackets that design brief being clear, any changes going out with that clear design brief could and should be properly accommodated within the change mechanism. My Lord, what, again, and by way of observation or comment, the evidence before the inquiry does appear to be to this effect, that NHSL wished to contract for a hospital that complied with the relevant guidance. And if that is so, again, by way of observation, it may well be that the error in the environmental matrix is irrelevant because NHSL wished and indeed thought they had contracted to secure compliance with guidance.
Sorry, can I just take that again? The evidence was to the effect that NHSL wished to construct a hospital that completed the relevant guidance. It may be that, now did we then go on to say that the error in the environmental matrix is irrelevant?
Because NHSL thought they had contracted for a hospital that complied with guidance. The environmental matrix, to make the obvious point, of course, is not guidance.
Right. I may need to be taken over that ground just again. I get the point that NHSL thought it was contracting within guidance. Now, and it's also their position that the environmental matrix was not of
Indeed.
a contractual effect to the contrary.
Indeed.
Now, I just want to be sure that I'm following your point. You emphasized the word guidance.
By that I mean SHTM 0301.
Yes.
And the point I make that if, and I realise that my Lord's not obviously resolving the dispute between NHSL and the contractors, but if the contract was to secure a hospital which complied with SHTM 0301, the fact that there was an error in the environmental matrix, which is a different aspect, a different factor, may well be irrelevant. I should add, my Lord, that the ministers do not enter into any discussion or debate about what the contract properly construed means. And picking up that last observation, a further observation is to this effect, again underpinned by the statutory framework and the practical operation of that. It is not for the ministers, respecting, of course, the way in which health boards deliver healthcare. It is not for Scottish ministers to, I might put it this way, mark NHSL's design brief. It's not for the ministers to check if that design brief has been drafted properly, if I might put it that way, so that it does in fact secure compliance with guidance. My Lord, another comment, if I may, relative to the question of staffing. And my Lord may recall that I took my Lord to section 12I in the various provisions, and also picked up section 12IG, which is the minister's strategic duty, if I might describe it that way, relative to ensuring staff are available so that health boards can provide properly staffed facilities. In that regard, in the minister's closing statement, paragraphs 17 to 19 provide my Lord with information relative to the topic of ICT staffing and what has been done in that regard. My Lord may recall there was some evidence at the inquiry session, and matters moved on since my Lord heard evidence relative to that. And the closing statement for the ministers at paragraph 17 to 19 provides my Lord with some detail relative to ICT staffing.
I should have the detail at my fingertips, but my recollection is that we've been provided with some written material.
As well, I think that's right. I think there's some, I can't remember offhand myself either, my Lord. It was obviously a topic my Lord heard some evidence about, and it's clear it's a matter of concern. And as I say, the updated position, as the ministers understand it, is set out in their closing statement. My Lord, I can now turn to the points, questions, or issues request made by my Lord in the paper. As I indicated at the outset, I propose only to address issues 1, 8, 9, and 10 for the reasons discussed. So far as question 1 is concerned, the minister's position is that this is really a matter for NHSL, whether or not a technical audit would be disproportionate, unnecessary, or the contrary. And I make that observation again because of the underpinning statutory framework. But I do make a couple of observations. First of all, and I think this has already been referred to yesterday, if there is to be some form of technical audit, how does that fit in with the contractual matrix and questions of design responsibility and risk? And at best, as we know from the chronology, any technical audit would only have disclosed the non-compliance issue about 5 months earlier than it was discovered. But as my Lord knows, by that time, the ventilation had been built. And would still have required remedying, or to be remedied, I should put it that way. Question 8 relates to the interim revision of SHTM 0301. The position on the part of the Scottish ministers is that this is a matter which is a function of NSS Assure. They are the experts on such matters. noting in that regard that one of the aims of Assure is to be recognised as experts in the field of quality healthcare built environment. And the ministers look to and rely upon that expertise. Regarding question 9, my Lord has the closing statement on behalf of the ministers, and I have nothing else to add to that closing statement. Finally, on question 10, the ministers agree with Counsel to the Inquiry's assessment to the effect that the arrangements put in place by Assure represent a robust challenge to help improve governance and compliance with guidance. But picking up the submission made by Mr. Ross on behalf of Assure this morning, Assure is at a relatively early stage of its journey. The ministers would expect Assure to continue to develop its expertise as time passes, drawing on experience and knowledge gained from research, past projects, past experiences, other jurisdictions, experts across all relevant disciplines in relation to the healthcare built environment. And indeed, my Lord may have got a flavour of that in the evidence provided by Assure, to the effect it will continue to develop and evolve so that it can be that source of excellence and expertise to secure the promotion of a quality healthcare service in Scotland relative to the built hospital environment. And one other aim I note of Assure is to facilitate wider collaboration as well. And on that point, question of collaboration and sharing of knowledge, I should again draw my Lord's attention to a submission made at paragraph 16 of the Minister's closing statement, which refers to a body known as the Strategic Facilities Group, which existed then and still does, and that is a further group used to share knowledge. My Lord, unless there are any other matters my Lord would wish me to consider and address, noting my homework, if I might describe it that way, those are the submissions on the behalf of the ministers.
Thank you very much, Ms. Crawford. That's sorry. We're now, I think, coming close to the 11:30 when we usually take a break. I would propose to call next on Ms. Donald on behalf of TÜV SÜD. Now, looking at the time estimate, I think it might just make sense if we break now, and I look forward to hearing from Ms. Donald at about 22:12. Now, Ms. Donald? Good morning.
Good morning, my lord. I appear this morning, my lord, on behalf of TÜV SÜD, and I'm.
Can I encourage you to use the microphone and remember that I'm hard of hearing?
I'll bellow.
Yeah.
Good morning, my lord. I'm appearing this morning on behalf of TÜV SÜD, and I am grateful for the opportunity to provide these oral submissions, which are supplementary to the closing statement already lodged. I intend to address specific points arising from the closing statement, which I formally adopt, address the specific points raised by my lord in his recent note of request, where it's appropriate for my clients to comment, and respond to some of the criticisms raised by other parties in their closing submissions and set them into the context of a public inquiry compared to a litigation in civil courts. My lord, my submission is in writing, but it's not quite in the state in which I would like your lordship to see it. I will tidy it.
I mean, there was no requirement to provide a written speaking note, Ms. Donald. It's just a question of speed. If I can take it down, that's good. But if I can't take it down and it's detailed, it's not very effective.
That's understood.
Yeah.
My lord, at the outset, it's my submission that it is inappropriate to consider Mr. McKechnie as an outlier in his views of SHTM 0301, the 2014 version, at least insofar as the evidence the inquiry has before it. He's described as an outlier in his lordship's note of request at para 6. As we set out in our written submission.
I think I picked up an expression used by counsel to the inquiry.
That's exactly where it came from, my lord, from counsel to the inquiry. As we set out in our closing statements, it is clear in hindsight that the 2014 guidance is open to different interpretations. It's our position that the inquiry has heard evidence only from one other independent witness on that interpretation, Mr. Maddox. As was set out in writing, Mr. Maddox has not referenced any other hospital in Scotland on which he has worked and where he knows that his interpretation of the Scottish guidance, SHTM 0301, has been used. The inquiry has not heard from any other witnesses to the effect that other hospitals in the same time frame or earlier have been designed and built in accordance with Mr. Maddox's interpretation of the Scottish guidance. For example, the new Dumfries and Galloway Royal Infirmary was opened in 2017. We had the Forth Valley Royal Hospital in 2011, although that I accept was earlier than the 2014 version of SHTM 0301. We don't have any evidence to disclose the standards to which those hospitals were built. In my submission, that may be relevant for your lordship to consider.
How is it relevant to the question as to whether this hospital was built according to
Mr. McKechnie's understanding and evidence was to the effect that he didn't understand other hospitals to have been built to a greater standard than was designed in this case. And if his understanding or if his interpretation of SHTM was taken by other parties in other hospitals, it would be of interest and relevance to the inquiry to know that.
Do you accept that anyone who we've heard about, who we've heard from or heard about, no one other than Mr. McKechnie argued for Mr McKechnie's construction?
Yes, I'll come back to that, my lord.
Right.
My lord noted in his note of request at paragraph 5 that he understood Mr McKechnie was supported by his employer in his interpretation. I can confirm that to be the case. Mr McKechnie was not indulging in a frolic of his own when considering the ventilation design issues for a major new health project in Scotland. He led the Wallace Whittle team of designers, an experienced team which had delivered other projects of a similar nature, as set out in his statement at paragraph 6 and in his oral evidence at transcript pages 126 to 127. Had others within the team disagreed with Mr McKechnie, then a discussion would likely have taken place. I put it no higher than that, my lord. A discussion may have taken place. The outlying view is a team one, held by the experienced and well-regarded design team. Internally, at Wallace Whittle, there were checks and balances to ensure that his design was compliant with guidance. My lord, those documents don't form part of the evidence, but they can be provided if the inquiry would like to see them, just to set out the checks and balances which are done internally. The usual checks carried out by M&E firms such as Wallace Whittle will be well known to other core participants in the same vein. There are a variety of internal reviews and approvals with review workshops where appropriate. In addition, whilst ventilation was very much a matter for Wallace Whittle to design, and that's accepted, drawings issued by the design team, not just by Mr McKechnie, were reviewed and commented upon by the Multiplex in-house technical team, as well as IHSL's facility management contractor, prior to submission to NHS Lothian and Mott MacDonald. In light of that, my lord, it's my submission that it's not a fair characterisation to state that Mr McKechnie could possibly be a single point of failure. I do note the IHSL submission to that effect as well. My lord, it's my submission that in the absence of a body of opinion, setting aside the fact that other witnesses now say that their interpretation of SHTM differed from Mr McKechnie's at the time, in the absence of a body of opinion with the requisite demonstrable experience of designing systems under the Scottish guidance in Scotland, to the effect that Mr McKechnie, whether alone or as part of his team, erred in his interpretation, it's my submission it's wrong, it would be wrong of the inquiry to take the line of least resistance and follow Mr Maddox, the English expert who was able to reference no experience of building Scottish hospitals under the Scottish guidance with which we are concerned.
Can I ask you a question which I asked yesterday? Lawyers consider that lawyers can understand documents. Am I not entitled to come to my own view as to what the document means?
I agree that my lord is entitled to come to his own view as to what the document means.
Sorry, you would...
I do agree.
You would accept...
You are. Mm-hmm. Thank you. My Lord, Mr McKenzie in his submissions yesterday noted the suggestion that Mr McKechnie's interpretation was wrong has only appeared during the inquiry or as a result of the inquiry. And he commented that in the period between 2014 and 2018, there was no evidence to declare that his interpretation of the guidance was wrong. As your Lordship has picked up, it is clear that Mr McKechnie has always held the view that his interpretation was correct, given the change made to Guidance Note 15. The corollary to that, I see, is that we have no idea what interpretations were in fact put on the guidance by others at the time. Mr McKechnie or his team were the only people to pick up on an inconsistency, to correct something in writing, such that your Lordship has it for posterity. We don't know what other parties' interpretation of the guidance was in 2014, other than what they are saying in evidence now, in hindsight. We can't know that other parties would have interpreted the guidance any differently at the time. It's not recorded. Looking specifically at Mr Maddox as being the appropriate expert in terms of the Scottish guidance, his report, sorry, my Lord, his report, that is the 12th December 2023 report, was relatively neutral in writing. He did not express a view on Mr McKechnie's interpretation of the guidance in that report, and it was not until he was specifically taken to the detail by counsel to the inquiry that he expressed that view. He was asked in my submission fairly leading questions to draw him to agree that Mr McKechnie's views made him an outlier. And that's Mr Maddox's transcript at page 45. His Lordship has referenced the other evidence on the interpretation of SHTM 0301 in his note of request, that's paragraph 5, and we note that both Multiplex and IHSL have confirmed in written submissions that the guidance, and it is only guidance, was open to interpretation. Finally, my Lord, in this short chapter of submission, it's important to emphasise and to remember that there was no incentive on Wallace Whittle to misinterpret the guidance. Had they considered the brief they were provided with to have been produced in error, then they may have raised it. It wasn't a difficulty for them to have raised any errors. It would cost them nothing and involve no extra work. Wallace Whittle were clear that the 4 air changes was a brief performance, which from their own review, and they concluded met the criteria for sufficient fresh air to allow the expressed rate of 10 litres per second per person. The adoption of 4 air changes, as was set out in the environmental matrix, does not change the design task facing Wallace Whittle. It simply alters the scale of the solution they have to provide. Just finally on that point, my Lord, I do note that a number of parties have counsel to the inquiry and others have commented that there was no bad faith intended on the part of Mr McKechnie and unsuggested by any party delivering submissions to your Lordship. And turning now to the note of request. In relation to question 1, whilst Wallace Whittle had involvement in respect of the technical resolutions and technical discussions prior to Settlement Agreement 1, they were not invited to participate in any discussions relating to the settlement agreement itself. They do, however, agree that it would have been appropriate for either NHSL or the Scottish Government to have instructed a technical audit. However, the comment they make is that it would have been appropriate for that technical audit to have been undertaken prior to the settlement agreement discussions. And by that I mean at the point where the technical resolutions were actually in the process of being agreed, to ensure that NHS Lothian was adequately supported when entering into agreement on the technical matters.
So, just so it's my fault. So, your position would have been that what it would have been necessary would have been prudent for NHSL to do what?
To consider a technical audit at the point.
Technical audit, and this would have been before March of 2018.
Around then when the technical discussions were taking place, before they were signed off. Turning to point 2, my lord. Although the high scribe process is one for the Health Board, Wallace Whittle are of the view that they believe the high scribe process should be followed in all healthcare projects. They do not consider that the process was properly adhered to in this case by NHS Lothian, and they take the view that there was an obligation on NHSL to go back to stage 2 of the high scribe procedure following the changes in the design of the ventilation system. In this, we are aligned, I note, with Multiplex, Mr. McKenzie's submissions yesterday.
Is that answer in the generality or in relation to the facts in this particular case, bearing in mind that NHSL, I think, as if I've understood it, take the position that, NHL's position was that the settlement agreement did not involve a change. Have I got that right?
The changes had already been agreed by the technical resolution the year before. So I think my client's position is that the high scribe should have taken place before, in advance of the settlement agreement.
Right. So it certainly as a matter of generality, if there is, during a healthcare project, if there is a material change in design which impacts or may impact on infection protection and control, you would say, as a matter of generality, the healthcare authority should go back to stage 2. Right.
Turning to point 3, my lord, my clients note this point is more for the Health Board and the project company. However, we do recognise your lordship's point that the independent tester potentially has competing demands and duties as a good one, and agree with Mr. McKenzie that the essence in instructing any independent tester is ensuring the instruction given to that tester is one which is clearly understood and covers what is important to the client. And I have in mind here that the original tester, Arcadia, tested to the project, the contract specification. When IOM came in, they tested to the guidance. My Lord, in passing, had the environmental matrix not been the brief for building the hospital, but rather that NHSL expected the hospital would be built to the guidance, whichever guidance they were referring to, then I wonder why Arcadia was not instructed to test to the guidance, but rather to the contract specification. There are other points in my submission to the environmental matrix being the client brief.
Well, presumably Arcadis was proceeding on the basis that they were testing having regard to the contract, their position being that as far as the ventilation specification was concerned, that you found the ventilation specification in the environmental matrix. I mean, presumably Arcadis was doing its work in relation to the ventilation system incrementally from a period before October 2018 until October 2018. And I think I've assumed that they were working to their understanding of the contract, and their understanding of the contract is the contractor's understanding of the contract, not the health board's understanding of the contract.
Yeah, I think.
Have I got that right?
Yes, I think that's my point, Lord. That everyone from the project side understood the contract to involve the environmental matrix, and it's only later when IOM are instructed to test to the guidance that the problems appear. My Lord, turning to point 4, the Wallace-Whittle understanding at the material time was that neutropenic patients were only one group of patients being accommodated within the Lochranza ward. They had checked that at the time with HLM architects. And my Lord, I do have an email. I did ask to see an email. I couldn't find it within the documents. I understand it has been submitted to the inquiry, and I have discussed it with your Lordship's team. If we need to find it, we can find it. Mrs. Robertson of HML explained in email correspondence that while neutropenic patients had been briefed as part of the patient group, they didn't make up the entire group. And I think in that submission I am at one with Mott MacDonald, because that appears to reflect their response to this, their written response to this question, which your Lordship had circulated yesterday.
Sorry, I'm being a bit slow on this. As you identify, the question is whether the Lochranza ward was constructed to guidance. Now, if neutropenic patient ward is to be equated with hemato-oncology, which I think is the way that Department C1 is described, the answer to that would appear to be it was not. Now, I think you're introducing a further factor, which is that, are you saying that Wallace-Whittle made some inquiry as to the patient mix in relation to Department C1?
Whether the whole department was to be regarded as neutropenic, that is the nursing station, the corridors, etc. And they understood from email correspondence that the specification referred to did not apply to the whole of the ward. And thus, we do not agree that the specification of neutropenic patient ward applied to the whole of Department C14.
But it would apply to the bedrooms.
The bedrooms containing neutropenic patients, if all patients were neutropenic.
Well, on the basis of the evidence I've heard in the inquiry, a particular patient may be neutropenic at a particular stage in his or her treatment. I think I've rather understood it that a hemato-oncology patient in the course of treatment is at least potentially neutropenic. I think I'm right in saying that there's 3 single bedrooms, 4 single isolation bedrooms, a multi-bed daycare, and 6 other single bedrooms in department C1. Now, as far as these bedrooms are concerned, are we agreed that as constructed, these bedrooms in Department C1 were not compliant with guidance?
We disagree that they didn't comply with the guidance. Our understanding from the material and the questions asked at the time in 2018 was that the environmental matrix did not highlight that all single bedrooms within the department were to have the capability of treating neutropenic patients. That's set out in writing in an email, which I will provide to the inquiry and ensure is available.
Well, there's maybe 2 issues here. Whether the rooms complied with guidance, and it would appear to me, at least if hemato-oncology is to be equated with neutropenic patients, it did not. There's another question, which is whether Wallace Whittle was led to believe that the circumstances were such that the department or certain bedrooms in the department did not require special ventilation.
The latter question, the answer is yes. That is what Wallace Whittle were led to believe.
And that depends on an email which we've yet to see.
I understand from my clients it has been submitted. I couldn't find it in the documents, but I don't profess to be an expert.
Do you have a date for the email?
The latest date in the email chain that I have is 19th March 2018. Email chain started on the 8th of March 2018. I can provide a copy if that would be of assistance.
Well, I'll welcome the information in order to understand it. I don't anticipate making any, well, we'll just have to see how things go, but if there's any real issue that arises out of this, because I appreciate this is arising out of a question that I asked, if there's anything arising out of it, I'll give notice to CPs, but I'd be happy to see the email. Yes, now where are we?
My Lord. Moving on to point 5. I have already made my submission on Mr. McKechnie and the position on oversight and scrutiny provided by the Wallace Whittle team and other parties to the project on the development of the design of the ventilation system and environmental matrix. My clients do wish to emphasise that the oversight provided by the other relevant core participants involved in the project throughout the design process cannot lead to the conclusion that any inconsistency between the specification for critical care and the terms of SHTM would have been identified earlier were it not for Mr. McKechnie's interpretation of the guidance. Furthermore, Wallace Whittle do not agree with the contentions of Mott MacDonald in respect that the lack of a finalised document clearly identifying, I realise I'm going a bit faster than I have been, my Lord. Wallace Whittle do not agree with the contentions of MacDonald in respect that the lack of a finalised document clearly identifying technical requirements for ventilation at financial close had no causal effect. A lack of any such document is contrary to accepted industry practice and poses a risk to any project. My recollection is that Mr. Maddox agreed with that. My understanding is that the current latest guidance issued by HFS records this as a prerequisite.
I'm not quite following this, and the fault is entirely mine. I'd be interested in your response to the contention, which I think is put forward both by a NHS Lothian and Mott MacDonald, that given Mr. McKechnie's interpretation of the guidance, any lack of clarity had no impact, because whether one looks at the environmental matrix or one looks at the SHTM 0301 through Mr. McKechnie's eyes, one comes to the same conclusion. So I, as I say, I would welcome, and maybe just, if I can throw in something else at this stage, do you accept that Mr. McKechnie's evidence was that he or his team had carried out a line-by-line review of the environmental matrix?
My recollection is that Mr. McKechnie offered a line-by-line review of the environmental.
I appreciate there may be two stages in this. I mean, is it right or is it wrong that Mr. McKechnie said that Wallace Whittle did carry out a line-by-line examination?
I can't recollect that detail, my lord.
Well, let's leave that out of the equation, but do you have a comment in relation to the argument that the difference between the environmental matrix and SHTM 0301 becomes academic if you look at these two documents through Mr. McKenzie's eyes, Miss McKechnie's eyes?
Yes, it becomes academic if looking at it through Mr. McKechnie's eyes, and if Mr. McKechnie is in error. My lord, in relation to the requirement for the finalised document clearly setting out technical requirements for ventilation at financial close, Mr. Maddox gave evidence to the inquiry where he noted in response, I think, well, it must have been in response to counsel to the inquiry, that the board's technical requirements for the ventilation system ought to have been in their final form by the time the project agreement and contract were signed. That's Mr. Maddox transcript, my lord, at page 16. I think that point was picked up by Mr. McKenzie in his submissions yesterday. My lord, on point 6, I addressed this issue earlier in my opening remarks. In relation to point 7, this isn't a matter for Wallace Whittle to comment on in our submission. Turning to point 8 and the issue of the interim 2022 SHTM 0301. My Lord, my clients invite me to point out at this stage that the fact that the changed version of SHTM 0301 was not in place at the relevant time is fundamental to the issue of design compliance. Though the guidance has now been updated, it would be contrary to logic to hold that the design specifications as implemented when the 2014 guidance was in place to the same standards as provided by the newer 2022 standards guidance. To lend support to this, my Lord, Wallace Whittle have also provided comment to me to the effect that their understanding is that the guidance contained within the new table in SHTM 0301 2022 has not been used within any other Scottish hospital at the time, it not having been governing guidance at the relevant time. My Lord, in terms of the question posed about whether there are any weaknesses or drafting deficiencies in the interim 2022 version, my clients are of the view that whilst the document is highly useful as a guide for dialogue between parties, they consider that the document is still, by nature, open to interpretation, and as such, does not lend itself particularly well to promoting certainty on design requirements between the parties to a project.
Right, just if I can get that. It's useful, but still open to interpretation, therefore?
Therefore, it does not lend itself particularly well to promoting certainty on design requirements between parties to a project. My Lord, I'll turn back to the guidance under point 10. We're discussing NHS Assure. In terms of point 9, I can confirm that the understanding is that the Wallace Whittle agrees with the potential recommendations proposed by Council. Turning to point 10 and NHS Assure, my clients agree that the arrangements put in place by NHS Assure represent a robust challenge to help improve boards' governance and compliance with guidance. I recognise the comments made this morning by Mr. Ross and Ms. Crawford in relation to NHS Assure being a relatively young body and one which is continuing to develop. One matter of importance, my Lord, in relation to NHS Assure is that I can't remember which witness gave evidence, but I do recall there being some evidence at the inquiry that staffing was difficult for NHS Assure. And provided NHS Assure have sufficiently qualified staff to deliver on their duties, it is a robust arrangement. My Lord, I said I was going to return to the question of guidance. As part of NHS Assure, my clients would propose or suggest that a review of all the current guidance be considered, such that, where appropriate, elements of the guidance may be produced as mandatory requirements. And any review would ensure that conflicting guidance be sifted out from circulation between parties to a project. And removing such conflicts would improve on compliance with the guidance, whether that guidance remained as guidance or became mandatory. Having suggested, my lord, that perhaps some of the guidance could become mandatory if a full review were carried out, I should say that I do recognise that where it does remain guidance, it needs to remain fluid to allow for changes in medical practices. And this recognises my clients' views, other views, that the clinical needs and patient safety should be first and foremost in defining the patient environment.
Sorry, I just missed that last sentence.
My clients sort of view, along with others, that patient safety and clinical needs should be first and foremost in defining the patient environment. Lord, as a final point on NHS Assure, my submission is, as instructed by my clients, that the current derogation process allows for some robust review of any changes. However, Wallace Whittle believe that NHS Assure, or a body such as NHS Assure, should be the body to take overall responsibility for approval or rejection of any requested derogation. And this is instead of it being by the health board or their technical advisors. Having NHS Assure as an overarching body to comment on such matters would be of great assistance.
Right, so Wallace Whittle would suggest that in any project, in the event of any proposal to derogate from a then current guidance, should be subject to the approval of NHS Assure.
Yes.
Is that what you've just said?
Yes.
Right.
Turning now, my lord, or turning away from the note of request and turning just briefly to submissions by other parties. My lord will appreciate where I'm coming from when I ask him to consider the nature and purpose of a public inquiry like this one. It's an inquiry set up under statute, intended to be inquisitorial, not adversarial, for your lordship to hear and test the evidence, to allow him to reach conclusions on what did happen and how it might be prevented from happening again. Core participants and recognised legal representatives are here only by the good grace of the inquiry, after having applications approved. The inquiry is not, in my submission, a forum in which to air matters which are more properly left to the civil courts. Recognised legal representatives are here to assist the inquiry, provide balanced and reasonable submissions, and not to advance arguments which are not for the inquiry. Lord, I don't suggest that arguments have been advanced that are not for the inquiry, but the way in which Mr McKechnie was characterised in some of the written submissions, in my submission, went too far. He's been characterised variously as an outlier, a single point of failure, and a golden thread. My clients do not consider these descriptions as fair or reasonable, not least because Mr McKechnie was part of a wider team.
I mean, as you've said before, you're presenting Mr. McKechnie's interpretation really as a Wallace Whittle interpretation.
Yes. He was part of the design team. I certainly don't demur from that, but it was a design team. And some of the characterisation in writing has, in my submission, been unhelpful. And I'll leave it at that for your lordship to make comment as he feels fit. My lord, my clients have asked that I highlight two fundamental questions to which we can find no satisfactory explanation or answer from other submissions or indeed from the evidence. In the original environmental matrix, it's not clear where the value of 4 air changes per hour originated. It appears to have been from the original Hulley and Kirkwood design, and it may be in my submission that that was their interpretation of the guidance. I couldn't find any reference to that in the evidence.
So this is a point as to, as it were, what was the mechanics when Halley and Kirkwood were preparing their first version in 2010? Sorry, is that the point or not the point?
Yes. Why did they put 4 air changes in? We don't know. The inquiry doesn't know. The second point, my lord, the second question that I'm asked to raise is why, if the 2014 guidance was so clearly interpreted, as suggested by NHSL and Mott MacDonald in particular, why was the 2022 interim guidance provided with such a fundamental and basic edition of the table, which we have reproduced in our written closing statement? It's my client's position that if the guidance was clear in 2014 SHTM, then that addition of the table in 2022 was not necessary. In essence, my lord, it's my submission that Wallace Whittle are being criticised for failing to comply with guidance which simply did not exist at the relevant time, and in respect of which we are only seeing retrospective interpretations. Just to finish on that point, my lord, Mr. McKenzie gave a submission yesterday, or made a comment in his submission yesterday, to the effect that until IOM came along in 2018, nobody had expressed a differing view from Mr. McKechnie. IOM expressed a different view, and that different view caused a delay to the opening of the hospital. That delay having been caused, it would be remarkable if anyone after that turned to the guidance and chose to adopt the interpretation provided by Mr. McKechnie. All I'm saying there, my lord, is that everything, we're looking back at this matter retrospectively, and it's very difficult for us to know whether, if Mr. McKechnie's interpretation had been interrogated by anyone, whether anyone would have come up with a different view at that time. That's my submission, my lord.
Now, can you just give me a moment?
Lord Brody, just one matter that you'd raised with Ms Donald was the issue about the line-by-line
Yes,
review, which is obviously something you're interested in, something that it may be relevant for TÜV to comment on. Your Lordship may wish to consider the transcript of the evidence from the 29th of February 2024. It's page 79 of the transcript and page 42 of the PDF. There's a quotation from an email, and then the question is posed to Mr McKechnie. It says here that TÜV SÜD had carried out a line-by-line review. Had that been done? And Mr McKechnie's response is yes. I think that was perhaps the chapter of evidence that your Lordship was considering.
That I think is what I had in mind. Can you just give me the transcript? I've got
Yes,
the
my Lord.
PDF
So
pages 42.
it's the transcript of the 29th of February 2024. It's PDF page 42, and it's page 79 of the transcript
79
itself.
Transcript. I don't know if you want to respond on that.
Thank you.
Say if you just yes, there's really maybe no need for comment, Ms. Donald, but the point I wanted to draw your attention to was at paragraph 24 of your written closing statement. And it's in relation to the reviewable design data process. And what you say there is that closing statement that Mr. McKechnie was unfamiliar with the concept of operational functionality goes on to note that Mr. McKechnie interpreted NHSL approval under the RDD process as confirming that the proposals were accepted. And then you go on to say, given the RDD process was operating as a conventional RDD process with comments being fed back on various elements, it's our submission reasonable for Wallace Whittle TÜV SÜD to rely on that. So, I mean, I think it's pretty clear there, but Mr. McKechnie and Wallace Whittle were working on the basis that if NHSL approved something, an item, a proposal, then that was acceptance, full stop, as opposed to acceptance that it was a way of doing it which was consistent with operational functionality. I think I'm really just saying that, I mean, have I understood what you're saying correctly?
I think the word approved might have been better than accepted.
Well, approved if you like. I think that was the only point. Thank you, Mr. Donald. Thank you. Mr. Thornley, on behalf of the parents and representatives of the children. Mr. Thornley.
Thank you, my Lord, for the opportunity to provide an oral submission to the inquiry on behalf of the patients and families. We have previously submitted 2 written closing statements after the recent hearings earlier this year and the hearings in 2023, which we adopt. We wish today to make a small number, I should say, of further comments and observations, and also respond to the questions raised by your Lordship. Now, counsel to the inquiry have identified a number of key themes which emerged at the hearing, which they set out in section 2 of their closing statement, which is at page 8, Lord. We propose to make a number of further comments about some, but not all, of these key themes. Turning firstly to the question of the guidance, my Lord, and that's in SHTM 0301, our view is that the guidance for the ventilation system was clear, and we agree with the submission by counsel to the inquiry in paragraph 35, where they state the problems with the project did not arise due to a lack of clarity in the published guidance for critical care areas.
Right, and the interpretation of critical care area is what?
Is as defined in counsel to the inquiry's closing statement, my Lord. We don't demur from that. Now, in terms of compliance with the guidance, we are very critical of the failure by the Health Board to follow the clear guidance set out in the High Scribe Procedure Stage 4, my Lord. And that's at paragraphs 5, 6, and 7 of our recent closing statement.
So you're critical of
the failure by the Health Board, my Lord, to follow the clear guidance set out in the High Scribe Procedure Stage 4. And that's referred to in detail at paragraphs 5, 6, and 7 of our recent closing statement.
Well, in what particular?
My Lord, we say the failure by the Health Board to follow that stage 4 of the High Scribe led the board to accepting practical completion and handover of the hospital when it was actually incomplete, which again is in accordance with the closing statement by counsel to the inquiry.
Well, maybe I should listen to you first, Mrs. Thornley, but I'm not quite following the point here. The NHSL did go through stage 4 of High Scribe. Are you criticizing? I mean, is the point that well, what's the point? That it wasn't done at the right stage, or what?
Yes, my Lord, that it was done too late, effectively.
When should it do? Are we talking about completion of stage 4?
Yes, my Lord.
When should stage 4 have been completed on your submission?
It should have been completed before the board accepted practical completion of the hospital, my Lord, which was at the time of January 2019.
Well, first point, why practical completion is an expression in terms of the project agreement, subject to certification by the independent tester. The High Scribe procedure is a requirement of HFN 30. Now, I suppose point 1 is Do you say they were necessarily connected?
My Lord, I don't propose to go into that level of detail. I think what I'm trying to say is that we're simply adopting what is in the closing statement of the counsel to the inquiry. I don't have the specific paragraph, but I could provide that later, my Lord. It's actually paragraph 40 of counsel to the inquiry's closing statement, my Lord, where the health board, the reasons given by the health board for failing to follow the guidance in high scribe stage 4 are set out, my Lord.
Right. So you're simply adopting 40.
Yes, my Lord. Now, if we take into account the purpose of the guidance, which is in the name, Healthcare Associated Infection System for Controlling Risk in the Built Environment.
I mean, you talk about guidance. I mean, am I not right in saying that we're talking about stage 4 at the moment, is mandatory?
Sorry, my Lord.
Is a requirement to go through the question set at stage 4, not a mandatory permission?
Yes, my Lord, that's correct.
Why are you describing it as guidance?
Well, I'm simply, to avoid any confusion, I'm simply adopting what is said in paragraph 40 there, and making a comment which will follow about the approach of the hospital health board. And to repeat, my Lord, what is said in Counsel to the Inquiry's closing statement of paragraph 40, by accepting that practical completion and handover of the hospital in its incomplete state, NHSL triggered its obligation to pay IHSL, the contractors, alleviating the risk of the latter's insolvency. And I'm simply adopting that, my Lord. I'm not going into any more detail. That is a matter for your Lordship to determine. My Lord, we further agree with counsel to the inquiry that when considering the risks associated with failing to comply with iScribe, the risk is that a hospital will be accepted as complete from a contractor when it does not provide a safe environment for patients. Now, turning to the role of advisors, my Lord, we've already commented in our written submissions on what we consider to be the confused state of the relationship between the health board and their technical advisors, Mott MacDonald. Despite all the evidence that has been led by both parties, we question whether we're any clearer as to what Mott MacDonald's role was as technical advisors. Mr. Barn yesterday for the health board said that Mott MacDonald were providing technical input and providing assurance to the board, yet Mr. McBrearty said their role was providing technical advice that did not include checking that the design followed the guidance. My Lord, in terms of the patients and families, we question what is to be made of that. And it's a matter for your Lordship to determine whether the technical advisors were providing reassurance to the board, which didn't involve checking compliance with the guidance in SHTMO 301. And I don't wish to go into any further detail other than make that as a general observation, my Lord. Now, in my submission, there's no acceptance of responsibility by the Health Board or Mott MacDonald for this confused situation about what technical advice was. And without such acceptance of responsibility by both parties, we consider that there is surely a risk that this may arise in a future project. My Lord, turning to the role of the infection prevention control, we adopt what is said by counsel to the inquiry at paragraph 53, where they say, had the guidance in SHFN 30 been followed and had IPC been engaged in the decision-making process around SA1, the problems with the ventilation system could potentially have been spotted at an earlier stage. And we've previously referred to the failure to involve the infection prevention control team until a late stage in our closing statements, my Lord. Turning now to the governance and oversight of the Health Board, again, we adopt what is said by counsel to the inquiry in paragraph 57 in relation to approval of SA1 by the Finance and Resources Committee and the Board. Both of these parties said they took comfort from assurances purportedly provided by Mott MacDonald, but neither of those bodies saw any written confirmation confirming this. And in our submission, it seems hard to believe, quite frankly, that they both effectively took this reassurance on trust without documentary confirmation. And that is simply reiterating what is said in paragraph 57, my Lord.
When you say it's hard to believe, are you challenging that evidence or are you doing something else?
No, I'm simply passing comment, my Lord. The account of the evidence is set out in counsel to the inquiry's closing statement is acceptable. Now, looking next to the Scottish Government and adequacy of the governance, at paragraph 61, counsel to the inquiry has asked your Lordship to consider whether more should have been done by the Scottish Government. And as pointed out there, they could have asked Health Facilities Scotland to conduct a review in advance of providing funding. The question is whether that would have detected the problem, and that is a matter for your Lordship. But it seems not unreasonable in our opinion, our submission, that they would have done.
Well, what stage are we talking about? What stage in the chronology are we talking about?
We're talking at the point that funding was provided around SA1.
Is that February 2019?
Yes, my Lord.
So, presumably before NHS Lothian has signed the agreement, or after it signed the agreement?
Before it signed the agreement.
And so what do you say Scottish Government should have done?
We say that they could have asked Health Facilities Scotland to conduct a review in advance of providing the funding. We don't go any further than that, my Lord, simply to say that.
Right, so you're not actually suggesting what might have been done, or are you?
No, we're suggesting what could have been done, my Lord.
So what would Scottish Government have asked Health Facility Scotland to do?
To carry out, well, I don't really think that's our position as the parents and families. The question is a broader one as to whether there should have been intervention by Health Facilities Scotland. And all we are suggesting is that that could have been done, my lord, not that it should have been done. And the next point I wish to highlight, my lord, is that the Health Board had a very highly specialised infection control doctor in the shape of Dr. Inverarity, who in our view could and should have been asked to assist more often, as it's clear from the evidence that he wasn't involved until the very late stages. And again, that is no doubt another matter for your lordship to consider. Now, in terms of the reference to Glasgow, in terms of reference 12, which was to examine whether NHS Lothian had an opportunity to learn lessons from the experience of issues relating to ventilation, water and drainage systems at the QEUH, and to what extent they took advantage of that opportunity. Lord, that there's been some evidence about that, which is addressed by counsel to the inquiry, paragraphs 303 to 310. And the evidence of Dr. Inverarity was that he was aware of some of the problems affecting Glasgow since it opened from his colleagues at the Queen Elizabeth Hospital. And he also raised an issue in an email dated the 4th of January 2019, flagging up the requirements for formal validation reports, which was before the SA1 agreement was signed. Now, the Scottish Government, we say, appear to have been aware of potential ventilation problems in Glasgow by the latest January 2019. And the Director of Health and Social Care wrote to every single Scottish Health Board on the 25th of January 2019, seeking confirmation that all of their critical care ventilation systems were being inspected and maintained. Now, my lord, we suggest it's not unreasonable that the government ought to have been on alert for potential problems with the ventilation system at the new hospital in Edinburgh, given that it was the same construction company, but we can't go any further than that on the basis of the evidence which your lordship has heard. And
I've got that submission. It's not unreasonable to be on alert.
yes, my lord. Now, the position of the Scottish Government in the evidence that we heard was that the blame was placed firmly on the Health Board, despite the fact that it was their money paying for the whole project. And in our view, that represents an abdication of responsibility by the Scottish Government, or at the very least, a major failure of oversight.
How do you respond to Miss Crawford's observations about the balance of responsibility between health boards in general and Scottish Government as set out in the 1978 Act.
I don't disagree with that balance of responsibility set out by Ms Crawford.
Right. Well, where do you identify the failure in governance by Scottish Government?
The question is whether, and it's for your lordship to determine whether the government were or ought to have been aware of a potential problem with the ventilation system in Edinburgh. Now, it's more ought to have been aware on the basis of a very serious problem that was developing at the Queen Elizabeth Hospital in Glasgow. And the evidence from Glasgow is that there was intervention at a very high level by the health minister towards the end of 2018.
End of 2018 or end of 2019?
End of 2018, my lord.
Right. What intervention do you have in mind?
So I'm talking about awareness, my lord.
I thought you used the word intervention. I may have misheard you.
I said awareness, my lord.
Right. So what do you point to as, what particular do you have in mind?
We've heard evidence. I mean, I can provide the details afterwards, my lord. But there was a meeting that was attended by the health minister with patients and families, and there's the letter sent in January by the Director of Health and Social Care about critical care ventilation systems, requiring them to be inspected and maintained.
Right.
Now, it's at a general level. It's not at a specific. It's what they ought to have been on notice or alert for, my lord.
Right. So. And what flows from that?
What do you mean by that?
Well, you've said that Scottish Government should have been on the alert. You've mentioned, I think you make a correct reference to a meeting between the Cabinet Secretary and I think patients in Glasgow, the end of 2018. Now, what do you ask me to take from that? Or what do you take from that?
That the government were aware of significant problems with the water and ventilation systems at the Glasgow hospital. And the evidence for that is the letter from the Director of Health and Social Care in the January.
And you say something more should have been done?
I think that there must have been an awareness of a potential problem, and the issues with the hospital in Edinburgh over the funding and the delayed construction ought to have been known to the Scottish Government. It would be very surprising, my lord, if they weren't. Now, in terms of the further matters raised by your lordship, the only matter that we wish to comment on is number 10 about NHS Assure, and whether NHS Assure presents a robust challenge to help improve board's governance and compliance with guidance. It appears to us that the new arrangements put in place are very thorough, although we note, as one of the legal representatives noted, that several witnesses expressed concern about the shortage of infection prevention control staff. And all we say is it's a matter for your lordship to determine whether NHS Assure would have been likely to identify the mistake that occurred. We do have some concerns about that, but it appears to be a robust process which has been put in place. And those are the submissions, my lord, for the patients and family.
Sorry, did you say that it does appear to be a robust?
Yes, my lord.
But you've got concerns about it?
I think some concerns were expressed by witnesses in terms of the staffing, and it's a new project. It's got much more much higher resources behind it than Health Facilities Scotland did, which it is effectively replaced.
Right, and that's what you propose to say?
Yes.
Thank you. Well, we'll take a break for lunch. Mr. McGregor, is 2 o'clock convenient to you?
Yes, my lord.
Right. We'll sit again maybe just after 2 o'clock.